Here, very well. Mr. Hurley, would you be kind enough to mute your mic until it's time for you to make your presentation? Thank you, sir. Ms. Lawrence, anytime you're ready.
Good morning. May it please the court. My name is Lindsay Lawrence, and I am the attorney with the Law Office of Robert Maylove, and we represent the appellant, Ronald Bray, in this matter before the court. I'm respectfully requesting 5 minutes for rebuttal.
Okay.
I'm requesting this court to reverse the conviction of vehicular homicide. The appellate filed a brief that brings to the court's attention 3 issues. During this oral argument, I will only discuss the first 2 issues from the initial brief. Before I discuss those issues, I want to give the court some background information regarding this case. In the case at bar, the appellate was charged with vehicular homicide and leaving the scene of an accident causing death. The appellant was found not guilty of leaving the scene of an accident with death and guilty of vehicular homicide. The state's theory during the trial was that while driving in an aggressive manner, the appellant's vehicle entered into the victim's lane of travel, which caused the victim to take an evasive action, which led to the victim's crashing into a semi that was legally parked on the side of the road. During the state's case in chief, the state presented 5 relevant witnesses that testified regarding the appellant's driving pattern. It should be noted that the facts of the interaction between the appellant and the victim were developed solely by eyewitness testimony. There was no—
And we understand, counsel, that your position has been that the previous actions of reckless driving are not relevant to the issue of vehicular homicide. And as I've read these facts over and over again, because you make a compelling argument, it's tempting. And I read it with an open mind thinking she's got a good point here, you know. But I truly don't understand how you can eliminate those sequence of events which all manifest itself in reckless driving, because otherwise the state would be left with trying to prove an improper lane change as a basis for vehicular homicide. And I just don't see how you do that. I know you've made the Williams rule argument, prior bad acts and all of that. It really isn't that. It's all one sequence of events. And I don't know how you separate it. So I know that's one of your key issues, and I'm just trying to help you get to it. So tell me why I'm wrong.
Okay, Your Honor, I had a feeling that you were going to ask about that. That is issue number 2, which is, issue number 1, which is the Williams rule evidence. And the important thing that the court needs to look at is the 5 relevant witnesses. And the one witness in particularly that the appellant believes that should have not been allowed or excluded to testify would have been Ms. Sutton. She is the individual who started following the appellant from Luckett Road to Colonial. And then after Colonial Road, she lost sight of the appellant. So she cannot testify what happened from Colonial Road to when the accident occurred. So there is a separation in time and distance during that period of time. It's not—
How much are we talking about?
But Ms. Lawrence, how much time and how much distance are we talking about?
So the record doesn't exactly tell us the amount of time, unfortunately, and the amount of distance, but we do know that the accident occurred at mile marker 135, and we know that Ms. Sutton lost track of the appellant at Colonial Road. Now, from our calculations, we believe that this is a period of 2 miles, more or less, but this is calculations that we did on our own that was not brought out in the record. But what is really important is this evidence of Ms. Sutton's testimony is used, that testimony is substantially different than the testimony of the different witnesses. And I know this court has actually just recently made decisions like DeSantis that look at these type of factors, right? And the court in those cases they're distinguishable from this case because that is a continuous pattern of time, and it's a continuous behavior of racing and speeding, where here the behavior of the appellant is substantially different from Ms. Sutton to the behavior that actually led the victim to go to the side of the road and cause the accident.
But doesn't this pattern give evidence for the jury to consider, which would bear on the decision that your client made to simply change his lane? Because if you take all of that information out, it looks like he's just an innocent driver driving down the road and he, whoops, made a lane change that was, which we've all done before. We've all sort of popped over, oh my gosh, there's a car there, I didn't see it. So if that's all you have, that's all you're going to think about. But if if the jury has all of this other pattern, they go, this guy, he was all over the road, he was weaving in and out. He clearly had a reckless sort of way about him. And this lane change, which might otherwise look innocent, isn't. It's part of this big pattern.
Respectfully, Your Honor, I would have to disagree. And why I disagree is I don't believe the behavior exhibited by Mr. The appellant was reckless. And that's why it's not a jury question, because the state didn't present sufficient acts or sufficient evidence to even get to the jury. And if we look at the FB versus state, that kind of gives the court some idea of what type of evidence.
Is that statement that you just made based upon your advocacy that all of this stuff that happened prior to the fatal lane change ought to have been considered Williams rule evidence and therefore not considered? Or are you suggesting that all of the testimony from the other witnesses describing this individual's driving pattern, that as a matter of law, that was not reckless, and the judge should have taken that away from the jury's consideration?
So that was a complex question. So first I'm going to state that the only evidence we think should have been excluded was the testimony of Ms. Sutton. The other evidence would not have been Williams rule evidence. And then when you look at the other witnesses and what they testify, it's the appellant's position that that does not rise to the level of recklessness, because not having ordinary care is not reckless. And recklessness requires a wanton disregard of human life. We know that that is not what happened in this case, because all of the witnesses that actually saw the accident first describe how he was in the left lane. Everybody discusses how he was first in the far left lane. Then he goes to the middle lane. And then three key witnesses, Mr. Spicuzza, Ms. Sohol, and Ms. Applegate, all discuss him going to the right lane.
See, what you've just done there is you just reframed what you said how you were framing it earlier. Earlier you were saying, no, I'm considering all of this other stuff other than this one witnesses. But then once you got down and drilled down to it, really is your position is there should be nothing considered other than the discrete act of going from the far left lane to the right lane, which ultimately resulted in the collision. That's the only relevant period that you think the jury should consider, right? That's your position.
That is my position, Your Honor.
Okay.
But if I may, the only person that doesn't describe that is Ms. Sutton. All the other witnesses are just discussing that in their vantage point. I'm not saying the court should not have allowed the testimony from the troopers and the person that identified the
right. Your position is that all of the stuff that preceded the two lane changes that ultimately resulted in this fatal accident ought not to have even been given to the jury, and moreover, had it been properly excluded, JOA should have been entered in your client's favor. That's your argument.
Even if not properly excluded, I still don't think that the behavior exhibited by by the appellant was reckless. And it's a very fact-specific inquiry that the court has to make regarding reckless driving. And I think it's
what do you think it was? If it wasn't reckless, what do you think it was?
That he was
all
not
this pattern.
that he was not using ordinary care. We don't have excess speed. We don't have fog. We don't have racing. There are so many more egregious factors that the court has looked to in the past to determine reckless driving. Here we have somebody who pretty much was going with the flow of traffic. Nobody actually gives.
But all these other drivers came out of the woodwork to identify this guy. I mean, they were all upset with what they experienced in dealing with him personally. So the fact that he got all these people riled up, it's, that's why I say if it's not reckless, is it careless? I mean, what is it?
I just think it's failure to use ordinary care. And even if the court
Okay.
thinks it's a little bit more elevated, such as careless, that's still not that is only a traffic infraction, careless driving. It wouldn't be a crime. So it still would be insufficient evidence and a JOA should have been granted, even with careless
But Ms.
driving.
Lawrence, I mean, the problem is that we're not a jury. I mean, ultimately what you're talking about is, I mean, if you take it in the light most favorable to the state, this is what juries are there for, is to decide, hey, was this guy just being careless or was he being reckless? I mean, you're making a good pitch, but I don't know how on the standard that you're asking us to weigh in and put our thumb on the on the verdict, to come in and take away a verdict on a, based upon your appeal. I don't know how we can do that when it does seem like you have to concede there's at least some evidence from which a jury could conclude this was reckless.
Your Honor, first I would like to say that the standard the court should be looking at is that the relevant evidence in light most favorable to the verdict. That's what FB starts to discuss. But in addition, I respect your opinion, Your Honor, but I really do not think
Thanks.
that this is something, I don't think that this is something that is a jury question. I think that the evidence that was presented shows that, sure, he was going in and out of pockets, right? However, if we look at the testimony of Spicuzza, he says that nobody else had to brake or was affected by his driving. Just because somebody doesn't like how someone's driving doesn't mean that it's rising to the level of recklessness. And in addition,
Ms. Lawrence, we got to go back and focus on what does the trial judge do? And Judge Lucas basically made this clear. At the time the motion for a judgment of acquittal is made, the trial judge has to say, look at the evidence, and has to look at the evidence in the light most favorable to the state. Okay, in the light most favorable to the state. And then the judge has to determine, should this go to the jury? Because I was a trial judge for a long time, and to take a case from the jury, it almost has to be tantamount to there's just nothing there at all. But the jury had the right to consider this evidence one way or the other and either agree with you, and as Judge Lucas points out, we're not the jury. So this is simply a very cut and dried question. I mean, for a judge to have taken this case from the jury would be egregious based on these facts. It would just, it doesn't take much. It's a very low showing for it to go to the jury. It has to be an extreme absence of evidence for the judge to go, this shouldn't even go to the jury, because you're taking people's case, you're depriving them of due process. That's not something we do lightly. We're going to err on the side of letting the jury make the call.
Well, Your Honor, I have the jury instructions in front of me. And what I want to point out is the third element that's required for vehicular homicide, which is that the defendant operated the motor vehicle in a reckless manner, likely to cause the death or great bodily harm to another person. And in order to have operated in a reckless manner, it requires the willful, intentional, knowing, and purposeful, wanton, meaning with conscious and intentional indifference to the consequences and with the knowledge that damage is likely to be done to a person or property. And here, Your Honor, the act that causes the victim to swerve over to the right lane, when that is happening, the appellant is moving to the right lane and then realize it might be a close call and then goes back to the middle. So the fact that he recognizes that it is a close call shows that he does not have wanton disregard. And the testimony isn't even clear how far to the right that the appellant goes. All we know for certain is that he touches the right lane, that he touches the line of the right lane. We don't even know the distance that he goes in. And that's why it's not a jury question, because the actions that caused the causation element, that caused the victim to react the way she did, although unfortunate, it is not something that rises to the level of recklessness. It was a great weather. It was a sunny day. There was nothing that was really occurring that made his behavior so egregious like the other cases, such as racing, like I talked about before, Your Honors. Okay, so since I have no questions, I mean, the key witnesses that I was going to discuss that help support our argument are Mr. Spicuzza, Ms. Kennedy, Ms. Applegate, and Ms. Sohol. I think that it's really important for the court to review Ms. Sohol's testimony because she really discusses how the behavior by the appellant was not reckless. And the court also needs to keep in mind that the trial attorney did not request a JOA on this matter. So that's something that we need to consider as well. And that Ms. Sohol even states there would not have been a collision with the victim, even if the victim had not swerved to the right. So if the victim had just continued driving and the appellant continued driving, it is Ms. Sohol's position that there would not have been an accident. And with that,
can I go back to the, I didn't mean to interrupt you, but I was focusing on what you said and what you reminded me that the key part of this case is defense attorney did not even move for a judgment of acquittal, right? And ordinarily that's just screams a problem, right? I mean, but in this case, would we be sound in our thinking if we said, look, he didn't move for a motion for judgment of acquittal, which is a really bad thing. But based on the facts in our record, we don't think that motion should have been granted anyway. Does that take him off the hook?
No, Your Honor. I think that his decision not to move for JOA was ineffective. I think that there was definitely an argument to be made that he should have moved for JOA and that this was not reckless behavior and that the state did not present sufficient evidence that met the elements required to
But
prove.
what if we disagree with you on that? What if the three of us get back there and say, look, this motion wouldn't have been successful anyway? Is that a valid basis for us to say, hey, you know, he probably should have made the motion, he didn't, wouldn't have been successful anyway, no harm, no foul? Is that a valid rationale for us to come to? Or must he have made the motion, period, no matter what?
If I talk about my practice, I would never not move for a JOA. But even if Your Honors think that it was okay, his behavior not to move for JOA, there's still two other issues that the court needs to look at, which is the motion in limine as well as the ineffective assistance of counsel. And I can go longer about this, but I know I'm 16.
Yeah, Ms. Lawrence, forgive me for interrupting, you're into your rebuttal time, so use the time as you wish, but I just wanted to give you the heads up.
If the court has additional questions, I'd be happy to answer them, but if not, I'd like to save the time for rebuttal.
Okay, you'll have four minutes for rebuttal, okay?
Thank you.
Thank you. If you could put your mic on mute, and now we can hear from Mr. Hurley.
Got it. May it please the court, Jonathan Hurley representing the appellee, the state of Florida in this case. We start first with the motion in limine, and that is the court's factual findings. So we're going to address this and whether or not the court below abused its discretion. That is, no reasonable juror could rule as the trial court below ruled factually. Factually, the court ruled that the entire driving pattern of the defendant was a continuous part of the same criminal episode leading up to the crash, accident, the incident. Based on what facts? Let's address the facts as presented. Witness Sutton, just so we have an idea, Witness Sutton testified between Luckett and Colonial, those exits, between, could be right after Luckett, could be right before Colonial. We just have to go on the language as presented, the evidence presented. So between. Now, between.
What's that distance? I mean, in our record, do we know that distance, or do we have to calculate mile markers and mileage, the speed limit? I mean,
I calculated it on Google for argument's sake, and it's 3 miles between Luckett and Colonial. It was presented, I think the defense presented something to the effect of 5 miles, but it's somewhere between 5 and 3. The state would argue it's 3 miles, but even in this case, we were saying between. It could have been a half a mile between Colonial. And
everybody's going 70 miles an hour at least, you know, between 70 and 75.
70 miles an hour
right?
on average. Some people
yeah, it's less. I mean, they're covering a mile in less than a minute.
We're talking 3 minutes is what we're dealing with here.
So, Mr. Hurley, would you agree that there is a time period or a distance period which would take prior driving behavior out of the picture?
Yeah, if it happened the day before, surely. Okay.
Well,
Some of the cases-
how about 6 hours before?
Come on.
I mean, relying on the cases presented by opposing counsel, as an example, that was 3 days before. So if we're going to compare, in this case, we're talking.
Mr. Hurley, hold on. I mean, that needs some testing. I mean,
I'm just saying that was the case presented.
yeah,
by
no.
opposing
Yeah,
counsel.
that was the fact pattern in that one case. I don't know that that sets the standard for all cases. I mean, let me pitch a hypothetical. So suppose I'm driving up to Ohio, a 2-day trip, and on day one, when I start out, I'm still in Florida and I'm furious with all the traffic in Florida and I'm driving like a maniac. But by the time lunchtime comes around, I get to the Georgia line and I start, kind of calming down a little bit. And then whoops, I make an improper lane change and unfortunately kill somebody. Would you say that my reckless driving in the state of Florida in the first part of my long journey would be properly admitted as evidence of reckless driving up once I got around Macon?
Respectfully, Your Honor, that's a different case and different.
Well, sure, that's what. But you just made.
I want to stick.
The unqualified and unequivocal statement that it had to be like a day, and I'm trying to test that a little bit because that seems to be maybe a little too much.
Respectfully, the review for this court is whether or not the court below abused its discretion when it found, based on these facts, not some hypothetical facts, on these facts, whether or not the court abused its discretion in finding it was a continuous pattern. And I'm laying out the facts as presented to the trial court when the court had to make this decision. We're dealing with a situation between Lockett and Colonial. The accident happened a mile south of Colonial. You also have, so we have Mrs. Sutton saying that this is where she starts to see, what does she see? She sees that she observes the defendant speeding. He's performing erratic lane changes. He's cutting other motorists off. He's tailgating. It's morning traffic flow.
So, Mr. Hurley, going back to Judge LaRosa's original question, you're not prepared to lay down a mile marker or a time frame that would be a bright line, but whatever it is, you believe that this case falls within it and it should all be considered and it's all fair game.
I think I'm not going to make a judicial determination of what a bright line is. That's not what the state's presenting here. The state is asking is representing that the court below in these particular facts did not abuse its discretion when it found a continuous pattern. Let me just finish factually what happened. You had in addition to Ms. Sutton, you also had Ms. Soho. Ms. Soho says she observed the defendant driving recklessly after she passed Colonial, but before Daniels. The accident happened before Daniels, after Colonial. So we have Sutton saying somewhere between Luckett and Colonial, that's 3 miles. And then after Colonial, the accident happened a mile after. So we could be talking, it would not be an abuse of discretion for the court below to infer within 1 or 2 miles, we have testimony, eyewitness testimony, that's in between 1 and 2 minutes. So the state would say, yes, based on a driving pattern, 1 or 2 minutes.
Are those distances or that, Mr. Hurley, are those distances or that time laid out in the record?
Yes, I just said on page 209 of the transcript, Ms. Sutton says between Luckett and Colonial, she observed the vehicle coming up from behind. Witness Soho on page 367.
Right, you told us the exits. I'm talking about the distance and the time.
I believe the defense presents in their argument that it was.
Yeah, everybody's looking at Google Maps, but nobody's pulling this from the actual record.
What I'm saying is that your argument was made in the record during the argument that then all parties settled on that this was clearly 5 minutes or less. That you can derive from the record. Okay. Because you have between Luckett and Colonial testified by Sutton, and then you have Soho saying that after passing Colonial but before Daniels. So if you simply do the math, somewhere between Luckin and Colonial is 3 miles, but somewhere, doesn't mean it's the entire 3 miles. And then you have the accident occurring in the record 1 mile after Colonial, and she's observed, and Soul observes erratic driving after Colonial, but before the accident. I think it was not, I think a reasonable jurist could find that this was a continual pattern of driving. That is what the state is arguing.
Mr. Hurley, can I shift gears on you? Because I'm really bothered by the fact that defense counsel did not make a motion for judgment of acquittal. I'm really bothered by that because, I mean, I got to tell you, I presided in crime for a long time. I don't think I ever saw any lawyer ever fail to make that motion, ever, one time. I mean, that just looks like ineffective assistance of counsel on the face of the record. It's shocking. I mean,
we can't glean tactically why from the face of the record, why counsel did that. I would, if you want me to.
Well, the whys aren't important. The fact is it happened. And does that basically, is this ineffective assistance of counsel on the record requiring a reversal all by itself?
Well, the why is relevant to whether or not.
What possible tactical reason would there be not to raise a JOA?
Okay, I will say that. After you had this extensive motion in limine, which almost was a judgment of acquittal from the standpoint of whether or not the evidence was relevant. So all this evidence is coming in and they're addressing the relevancy to the charge of reckless driving. That is, we have to prove not that this person was negligent, but this person intentionally drove with a wanton disregard for other safety. And how are you going to prove that? You have to go back and look at the way this pattern of this driving, that this just wasn't a one-off jerk of the steering wheel, that this person for 3 or 4 minutes was recklessly driving erratically, as testified to by numerous witnesses. Witnesses testified again, as I repeated, all of this came in before during the limine argument, that there was speeding, that there was erratic lane changes without signaling, that there was cutting motorists off, that there was tailgating. So all that evidence was presented already, and the defense counsel already knew where the trial court stood on that, because the court determined as a matter of law that that is relevant to the state's charge. So what is the defense counsel doing? What defense counsel really was doing was focusing on the second charge, and that was leaving the scene of the crime. Because if you review the record, there was an issue of whether or not you had to prove, did he actually hit the person? Was it, what does accident mean? Did you actually hit the person or not? So not surprising, the jury came back acquitted on that second charge, because it wasn't clear on the record whether or not the defendant actually hit that individual, meaning was alerted to the fact that they hit this person and then knowingly left. So the jury could say, well, you know, we're not sure about that. And not surprising, they came back with a not guilty on that. So therefore, counsel strategically maybe is thinking, again, I'm speculating, I can't get into the mind of defense counsel. We need a 3850 to do something like that. We have to say, well, I'm not going to, just like in an appellate argument, I'm not going to go with my worst argument first. I'm going to go with my strongest argument first.
But the JOA doesn't go to the jury. The JOA argument doesn't go to the jury. It goes to the judge.
He's trying to gain some respectability with the judge after going through.
That's the tactical basis. Is don't put forward a loser argument.
Again, I'm not the trial counsel. I wasn't there to get into his mind why they were thinking that. I think if you want to have
the riskiest strategy I've ever heard.
I don't think that's a strategy at all.
Well, let's just say this. It's clear that there was more than a scintilla of evidence presented that the individual drove recklessly. I just rattled off 5 things that the individual did that in other cases were relevant to not whether or not the person drove recklessly. So
it's a really brief JOA argument, but at least you make it, and that way you've got the issue preserved. By not making it, you leave your client without being able to make it on appeal. I mean,
there's no upside.
There's nothing there. Just concede. There's no tactical reason to do this.
Hurley, hold on for a moment while my colleague.
Regardless of the evidence, if you don't make a per se JOA, or if you don't make a JOA argument that per se that's ineffective assistance on the face of the record, regardless of the evidence presented, is that what this court is proposing?
Yeah, I'm thinking about it actually. I mean, it's that bad.
You know, I don't think that's the standard for ineffective assistance of counsel, at least based on my study of the law. So we have, tactically, that's not what's at issue here. And whether or not, if opposing side wants to have a 3850 and flush this out with an evidentiary hearing where this could be determined, so be it. But on the face of this record, based on the evidence presented, I don't think you can say, as a matter per se, this was ineffective assistance of counsel on the face of the record. So going back to the limine argument, so factually, not abuse of discretion to find this continuous. Is it relevant? Is it relevant that we have a continuous pattern of reckless driving? Yes, it's relevant. Why? Again, the state had to demonstrate that this was an intentional conduct on the part of the defendant, not a simple negligent one-off turn of the wheel. So obviously, for the state to be able to present its case, you could not eliminate that evidence. As far as the JOA, of course, right? We all talked about it. It was not preserved, but it's also not fundamental, because for it to be fundamental, you'd have to demonstrate that there was no crime committed in this case. And I just went through exhaustively how at a minimum it was reckless on the part that the individual operated this vehicle in a reckless manner based on at a minimum, the speed, the traffic flow, the weaving in and out. According to both Spicoza and Kennedy, you had in addition to the prior driving pattern going in and out, in this particular incident, he was in the left-hand lane. He bypassed right through the middle lane, skipped right through it, 1 to 2 seconds, no blinker whatsoever. Improperly, there's evidence demonstrating that he, in fact, improperly veered into the lane. That was testimony presented, veered into the lane. Didn't say that he hit her, but veered into the lane. That veering coming from the speeding lane all the way over into the slow lane, skipping the middle lane, caused the victim to veer her car. Unfortunately, we're talking the speed 70, 75 miles an hour, and lose control. And ultimately, obviously through bad luck, there happened to be a semi right in there. But that's the causation, was the coming right over, improperly going into someone's lane. So based on the evidence presented, there was no abuse of discretion. There was no error by the trial court in the limine based on the charging document, based on the evidence that was presented showing it was continuous. As far as the JOA, based on the record, there is definitely more than a mere scintilla of evidence demonstrating reckless manner of driving. It was not fundamental because, again, as a minimum, you have reckless driving. If there's no further questions.
Thank you, Mr. Hurley. If you could mute your mic, we'd appreciate it. Ms. Lawrence, 4 minutes, please. Go ahead when you're ready.
I'm not going to address the ineffective assistance of counsel argument that Mr. Hurley just spent time discussing. I think that the brief is very clear that the court has the ability to address ineffective assistance of counsel on appeal. I want to harp on some of the other arguments that Mr. Hurley presented to the court regarding recklessness. First, he discusses the speed. And as the court, I'm sure, is aware of, speed alone is not enough for reckless driving. It has to be gross or excessive speed with additional factors that in order to be considered reckless, which we just don't have here. We know that based off of the testimony. In addition, I want to bring the court's attention back to Ms. Sutton, what the record is clear says that she arrives to the accident 5 minutes after she loses sight of the appellant. And that is clear because that shows that she does not see this continuous pattern. And what I would like to equate this to is kind of like an abandonment defense, because we don't know if between when Ms. Sutton saw the appellant and when the accident occurred, if he had the same driving pattern before. Therefore, he could have abandoned his behavior. And in addition, the type of driving that Ms. Sutton describes of the appellant is not the same type of driving that the other witnesses discuss of the appellant. And that's very important to note, that there is no continuous pattern and that it was the state's burden to show a continuous pattern, which it did not meet based off of the evidence that was presented throughout the trial. All these questions that the court has been asking about distance and time, these are not questions you should be looking to defense or the appellant for the answers. You should have looked to the state for these answers because it's their burden of proof, and they did not present this evidence in their case in order for us to have answers regarding it. So the defense should not, you shouldn't look to us to see what the answers to that are. I understand there's discrepancies about what the distance, if it was 3-5 miles, but in the end of the day, it's the state's burden, and they didn't show those things during their trial. And then the court has to ask, how did Ms. Sutton's testimony assist the jury? It didn't assist the jury because we don't know if this was a continuous pattern. Therefore, it's not relevant. And even if the court determines that her testimony was relevant, it was more prejudicial than probative, and it should have been excluded. In addition, Mr. Hurley discussed how he was also reckless because there was no blinker. There's a discrepancy in the testimony whether there was a blinker or not. All these additional factors that the state discussed just now that show reckless driving, it's the appellant's position that these factors do not rise to the level of reckless driving. At most, it's failure to use ordinary care, and that is not enough for vehicular homicide. Vehicular homicide requires the court to make a finding of reckless driving. We don't have these additional factors to get there. And because we don't have these factors, we can't meet vehicular homicide. So with that, I just want to harp on the importance that the reckless driving was not met. There was no continuous pattern from the appellate that Ms. Sutton could testify about. And there is the possibility that Mr. Bray abandoned the pattern that he had when Ms. Sutton witnessed the driving. And therefore, I respectfully am asking that this court reverse the conviction and discharge Mr. Bray of the crime of vehicular homicide. And I know my time is up, so unless the court has any additional questions, I will rest. Thank you.
Thank you, Ms. Lawrence. Thank you, Mr. Hurley. Well-argued case.
I appreciate it.
So now you will be moved back to wherever you came from.
Have a great day.